Thank you, Mr. Mahinda Sirivardhana, Secretary. Thank you very much, Secretary to the Treasury, for the opening remarks. DSTs, Director Generals, especially Mr. Padma Priya and Udesh, who invited me to do this presentation. In Secretary Treasury's opening remarks, he mentioned several initiatives in the area of digitization, which are of significance that has been achieved by the government over the years, and gave reference specifically on the importance of the digital identification initiative and many other projects that has been supported, facilitated by the Treasury, implemented by many governmental organizations over the past few years. Now, in that entire digitization journey, many regulatory interventions have come in through a number of statutory measures. So, Secretary to the Treasury was formerly also Deputy Governor in the Central Bank. I knew him at that time. Central Bank was in the forefront of developing digital standards thanks to the initiatives taken in around early 2001 under the Banking Sector Modernization Initiative, where a lot of novel initiatives were started in the country. And now we take it for granted that transactions between banks, customers in the banks, with the press of a button can do transactions. Even salaries are paid through the slips system. So if you look at what was done to enable slips, Sri Lanka Interbank Payment Systems, SEFT, real-time gross settlement systems, the CITS, check imaging truncation system, all of these were done through changes to the law, starting with the Monetary Law Act amendment in 2002, and then culminating in several other laws, including the Payment and Settlement Systems Act number 28 of 2005, which was accompanied by certain evidence law reforms that were carried out to ensure that those transactional records will be admissible in courts. Now, while those were regulatory laws that were done from time to time and enacted by Parliament, we also had a lot of enabling laws, right? So we have the Electronic Transactions Act, for example, Electronic Ganudenu Nitiya. Mr. Padampriya mentioned about it, Act number 19 of 2006, which provides for legal recognition of number of electronic records documents, including electronic filing of documents in the public sector. In Section 8 of that Act, you have, for example, an entire framework under which any manual-based documents you have in government, in any records, files, can be indexed, stored, archived, and presented by way of electronic evidence to courts under Section 21 of the Electronic Transactions Act. So that was an enabling law. But we know digitization initiatives that had to be embarked. All government departments didn't embark in the same way. Some did it slowly, some did it expeditiously. We saw organizations like the Immigration Department, Registration of Persons Department, Pensions Department, of which we was part of, and many other governmental initiatives resulted in Registrar General and others automating, digitizing the processes. Number 19 of 2006. So electronic monitoring here. තමයි baseline එක උනේ මේ රටේ digitization සම්බන්ධයෙන් electronic data, electronic records සහ electronic signatures. So even central banks, Lanka signed initiative that was launched in 2009 to enable SWIFT, SEF, and all those banking transactions happen, was facilitated and regulated by the electronic data. So those were broadly laws which are enabling by its nature, but we also saw later down the line other laws coming in, including the Computer Crimes Act number 24 of 2007, which took care of the abuse aspect of it, right? And then other initiatives were done over the years. Now, the Personal Data Protection Act number 9 of 2022 is a law that came in many years thereafter. It took time for the stakeholders to understand why this is important. This law is both a facilitating law as well as a regulatory standard setting legal framework as well. So, if you look at the law by itself, it protects all those people who have given their personal details, which are in either paper format or which are digitized, which are available to government and private sector organizations for processing. So what is processing? I will come to the definition in a little while. We have some unique definitions. One is processing, one is personal data. What is personal data? It has been defined. And if you look at the overall ambit of this law was done with the objective of protecting individuals called data subjects. So let's see down the line how data subjects have been defined. So if you understand the meaning of data subjects, what is personal data, what is processing, this law is about enabling a framework to protect and safeguard those three subjects I mentioned and to provide the regulatory structure for those three areas I just mentioned. So, මම මේ පෞද්ගලික දත්ත ආරක්ෂණ පනත මම හිතන්නේ හැමෝටම දීලා තියෙනවා නේ කොපිස් එකක් නෑ ඒක ෆිල්ම් කරන්න බෑ මේ කොපිස් ප්‍රශ්නේ ඩිස්ට්‍රිබියුට් කරන්න එක තියාගන්න මොකද මම ඒක මේ ප්‍රසන්ටේෂන් ස්ලයිඩ්ස් වලින් කවර් කරන්න මේ law එකේ preamble එක long title එක බැලුවොත් මේක සඳහන් වෙන්නේ පෞද්ගලික දත්ත සැකසීම නියාමන කිරීම පිණිස පෞද්ගලික දත්ත ආරක්ෂා කිරීමට අදාළ දත්ත දායකයන්ගේ අයිතිවාසිකම් හඳුනා ගැනීම සහ සත්‍යමත් කිරීම පිණිස සහ දත්ත ආරක්ෂක අධිකාරිය පිටුවීම සඳහා තමයි මේ පනත මේ පාර්ලිමේන්තුවෙන් සමත කරේ. The primary reason why this law was considered important was because for two reasons. I have explained those reasons here. In the slides, we have said that over the years, when Sri Lanka embarked on various digitization initiatives that Secretary to the Treasury kindly mentioned, and we have had a lot of successful initiatives, including the South Asia's first e-visa initiative, which was a bit controversial subsequently, but nevertheless, we were the first in South Asia to get that electronic visa system done, recognized and facilitated through online payment methods, enabled under the Electronic Transactions Act. In all those situations, we have data. How do we protect and safeguard personal data? Why is that important? For two reasons. In the context of promoting digitization and through digitization ensuring transparency, we have to embark on more and more digitization initiatives, including the digital ID project that Secretary Treasury mentioned. But for the end users, the citizens at large, for them, what matters is the confidence level we create from the government side for them to freely give our personal data. So how do you create confidence and trust in the digital ecosystem? That is achieved primarily through the Personal Data Protection Act number 9 of 2022. Second thing is, when we embark on digitization and improve transparency to attract investment, and when we embark on big ticket items, like if we are to attract Microsoft to expand the operations and make this a hub to create more employment opportunities, if you want to attract Amazon or Google to attract investments into the country and attract them into the country to make this a hub in the same way some countries in the region or in East Asia are doing. What are they looking at? They look at the Doing Business Index, they look at our Transparency Index, Corruption Perception Index, and they look at these kinds of laws, how effective they are. And Secretary of the Treasury might be interested to hear this, that in a recent discussion we had with some of these large providers of digital services, when they look at the country, in the same way they look at the quality of the central bank, they look at the characteristics and the quality of the regulator and who runs the regulator, the quality of the staff and the ability of that staff to engage in a proactive, meaningful regulatory initiative to create digital trust is a fundamental boardroom level discussion in all of these big investors who want to come in. If we do have only just a paper regulator, right, just on paper and not effective, then we will not qualify as a country to attract big investments. So this law was important, A, to create digital trust, B, to attract digital investments, and on the third side, the third important point is, we know for certainty when many top Sri Lankan companies want to embark on businesses overseas, and when they go and lobby for businesses, let's say in Europe or US or Australia, and go on international marketing initiatives, they look at the country of origin. And I know personally, talking to some of the members of the SLASCOM, how at least 3 large projects were lost for Sri Lankan companies. So they look at Sri Lanka, they go to the boardroom for the final presentation, they ask, okay, from where are you? They are from Sri Lanka. What are the standards of effectiveness of implementation of the Electronic Transactions Act? Do you have a Data Protection Act? What is the quality of the regulator that you have for data protection in your country? And I know at least 3 cases where Sri Lankan companies have eventually gone for a rebid. You might like to hear this. after registering an offshore company either in Dubai or Singapore and not going as a Sri Lankan company. And where is the income from those projects, revenue generated from the projects going to? Are they coming to Sri Lanka? I leave it to you to decide where it will go. It's an open secret that the money is generated from large international projects of Sri Lankan companies eventually end up either in Dubai, Singapore, Australia, or US accounts. Why? Because we have not done enough to support our private sector companies by bringing in laws like this, but not only just the law, but not creating enough kind of support for regulatory structures to be developed. And I'm happy in that context that the Central Bank Act of 2023 was enacted, because that at least creates a very good image for the country that we have an independent regulator for the banking sector with quality staff capable of dealing with international partners effectively. So in the same way, if you want to succeed in the journey of digitization, we have to create stable, sustainable, effective, quality institutional frameworks. So that's why this law was important. So in terms of background, I am mindful that we are running out of time. I will try to rush the next few slides, but I think the importance of this is something that I want to highlight. In terms of background and the process for developing the law, I just want to highlight two important points. Number one is Sri Lanka අපේ අනුකරව ව්‍යවස්ථාවේ දත්ත ආරක්ෂා කිරීම සම්බන්ධයෙන් අයිතිවාසිකමක් නැහැ. Fundamental right to privacy is not guaranteed under the Constitution, but there are important case law from the Supreme Court which has recognized this concept of data privacy in a number of cases by reference to international human rights conventions that Sri Lanka is a party to. Many of you are aware that we are a party. In the 1980s, we ratified the United Nations Convention on International Civil and Political Rights, ICCPR. Under ICCPR, there is an entire article dealing with the right to privacy. Although it is not embedded into our constitution, because we have ratified some of these provisions of law, it goes without saying that we have certain rights emanating from international law, which is now absorbed into our how bringing us in the absence of the constitution. But there was an opening. That opening came from the 19th Amendment to the Constitution under Article 14A, where there is a fundamental right to information. And we know the Right to Information Act of 2016 came from that. But that applies to public authorities. It applies to all of us, all of you. And the citizens can ask for various kinds of records from all of you. I know it can be a headache for many of us, right? I have also been at the receiving end of managing this, although I was also one of the members of the drafting committee of the Right to Information Act. I know the implementation challenges, but that was done with a good intention to ensure transparency, effectiveness, and a proper governance framework. But in that Article 14A, there is a proviso saying that by written law, safeguards can be brought in to protect and exclude release of information from public authorities in situations such as national security, criminal investigations. And it goes on and says privacy. So that is kind of, it recognizes that privacy and protecting individual rights can be an exception to the right to information provision in Article 15A. So one of the challenges we think we may have in the future is ensuring the right balance between the right to information on the other hand and protecting personal data on the other hand. And in the case of personal data, under the Personal Data Protection Act number 9 of 2022, it applies to the public sector. The law applies to the public sector and to the private sector, whereas the Right to Information Act only applies to the public sector. So that's the interesting constitutional aspect we have to deal with. And then in looking at best practice models to develop the law, we looked at all these international instruments, legal statutes that are mentioned under the second bullet item. And of course, the third highlight in terms of process in drafting this law, what was done was a transparent process. When I was asked to share the drafting of the drafting committee for the Personal Data Protection Act, I agreed to do it. And it was interesting that the central bank itself had the initial stakeholder consultation in the context of improving the investment climate and protecting Sri Lankan businesses that are trying to do investments in other countries and attract investments back to the country. So when the central bank had that discussion and wanted us to draft it, we agreed it on two conditions. Number one, that we have a public-private kind of committee. Normally these laws are drafted with only government officials, right? That's not a bad idea. We have very good people in the Legal department, we have good people in the Legal Drafts department, but sometimes we often miss finer points. And the private sector perspective and the non-governmental perspective is not included. So what I requested the then Governor Kumarasamy was in the cabinet paper to enable us to have a true public-private drafting committee. So it was a public-private partnership there. Number two was many of our laws are drafted in closed doors. Is it good or bad? I will leave it to you gentlemen and ladies to decide whether it is good or bad. History has proven that the laws drafted in a transparent way has been effective and has had the stakeholder buy-in more effectively and efficiently, and absorption is faster. So what we did was, we drafted this law and we requested approval to publish every single version. So the first consultation paper, it was a very strenuous, very difficult exercise, Honorable Secretary and PSTs and PGs, very difficult. And there was opposition also from some of our authorities from the legal, governmental legal sector. But nevertheless, we took the challenge. We published the first consultation paper, framework paper, on the 16th of June 2019, and thereafter had the first public consultation on the 27th of June. And then thereafter, we had 7 rounds of stakeholder consultations, which resulted in 33 written submissions. And all of that over 2 years helped improve the quality of the product and made it an internationally compatible law, enabling us to have cooperation not only with European Union, World Bank, ADB and other partners, but with the United States, China, Japan, Australia, Singapore, India, and many other countries. So, having said that, a couple of important points to highlight. I mentioned this at the beginning. This law is about providing a regulatory framework for the processing of personal data and to identify and strengthen the rights of data subjects and to establish a data protection authority. But the preamble to the statute, right? පූර්විකාවේ මේ පනතේ පැහැදිලිව සඳහන් කරලා තියෙනවා මේ කාරණා දෙක. දත්තදායකයන්ගේ පෞද්ගලික දත්ත අයිතිවාසිකම් ආරක්ෂා කිරීම සුරක්ෂිත කරන අතරම ශ්‍රී ලංකාවේ ඩිජිටල් ආර්ථිකය වර්ධනය කිරීම හා නවීකරණය කිරීම සඳහා පහසුකම් සැලසීමට අවශ්‍ය වී ඇති හේයින්ද. දෙවැනි කාරණය තමයි පෞද්ගලික දත්ත ආරක්ෂණ රාමු අතර අන්තර්ක්‍රියාකාරීත්වය වැඩි දියුණු කිරීමට මෙන්ම පෞද්ගලික දත්ත ආරක්ෂණ බලාත්මක කිරීමේ අධිකාරීන් අතර දේශ සීමා හරහා වන සහයෝගීතාව ශක්තිමත් කිරීමට අවශ්‍ය වී ඇති කියන කරුණු දෙක සඳහන් වෙලා තියෙනවා. So what it says is that this law is supposed to enable the growth and innovation in the digital economy whilst ensuring the protection of personal data and the rights of data subjects. Secondly, to improve interoperability between data protection frameworks here and abroad, and to strengthen cross-border cooperation between enforcement authorities. So the Data Protection Authority Sri Lanka cannot act in isolation by itself. They are supposed to create an interoperable regime. And why is interoperable required? To attract investors, attract international engagements into the country in relation to this subject area. Now, final point on this note is, in this slide is, date of operation. We might ask, මම එකේ සඳහන් කරා ඉස්සෙල්ලා මේක රජය ආයතනවලට සහ පෞද්ගලික ආයතනවලට දෙකටම අදාළ වෙන නීතියක්. හැබැයි මේ නීතිය කවදාද ඉෆෙක්ටිව් වෙන්නේ? ජනවාරි 8 වෙනිදා Gazette, extraordinary Gazette was published by the President. In that Gazette, under the Data Protection Act, two things were highlighted. Firstly, the administrative and governance aspect, creating the fund of the Data Protection Authority, enabling staff to be appointed for the authority, was brought into effect on with effect from 1st of December 2023, because in July 8th, I think, of 2023, the President issued a Gazette bringing into operation Part 5 of the Data Protection Authority, under which the President had to appoint the chairman and the board members of the Data Protection Authority. The chairman and the board of the Data Protection Authority was appointed in the first week of August last year. And the first meeting was held sometime latter part of September. And we have our acting Director General Varuna here. The office was established sometime at BMICH around December last year, and since then efforts are being made to recruit the staff. Now, when will the law come into operation? The 8th January 2024 Gazette clearly says that the law will become effective and enforceable from 18th March 2025. So we can't wait till 18th March 2025 to make that Data Protection Authority effective and meaningful. The staff, we are already delayed in terms of recruiting of the staff, and hopefully that will get resolved soon. And thereafter, what is going to be done at this moment in time, the board members are working on a voluntary basis, and they are developing the implementing rules, regulations, and guidelines. And that is what is happening now. In terms of definitions, I mentioned about personal data, what it covers. පෞද්ගලික දත්ත. ඒකේ interpretation එක නැත්නම් meaning එක අපි මේ පනතේ සඳහන් කරලා තියෙනවා. It covers our individual identities, like our identity number, our personal address, telephone number, and also maybe our email address or our social media identification profiles, right? All those areas are recognized in the definition of personal data. Now, we all know when it comes to income tax records, pension records, our identity card process, right? When we apply for an identity card, what happens? What happens when we enter our children to school? The parents' details, our children's details, all are given. All these are personal data that comes under the protection of the Personal Data Protection Act. Then who are the people protected under this act? Data subjects. Data subjects mean identified or identifiable natural persons, including those living and those who have died, to whom the identification number, telephone record, address, email address will relate to. And very interestingly, the definition of data subject includes not just citizens. Those who come to Sri Lanka, who apply for the online visa, come and check into our hotels, book airline tickets from Sri Lankan Airlines, all those people are protected. So remember, foreigners and Sri Lankans alike have the same rights under the Personal Data Protection Act. There are several Supreme Court judgments, starting one famous one in the 1990s. Article 12(1), right to equality under the Constitution, is a right available not only to citizens, but even to foreigners alike. So the same principle is included here. Then comes the definition of a controller and a processor. And in this definition, you will see many entities recognized. And you have something called a public authority. And the public authority definition includes a ministry, department, statutory body. Non-governmental organization, of course, comes under the definition of a controller. So remember, all of your departments under the purview of the Treasury, including the Inland Revenue Department, Customs Department, that is collecting personal records, will be regulated under the Personal Data Protection Act, and enforcement action against all those organizations are possible from 18th March 2025 onwards. A processor in this law has been defined as an organization that has been contracted by the controller to perform certain functions. So we have examples of that in the treasury systems, right? You have RAMIS, Revenue Administration Management Information System, that I think the then Treasury Secretary and the Income Tax Department head, Director Commissioner General, signed that agreement. And we have outsourced certain functions to a foreign company. Is that foreign company liable and regulated under this act? Well, they are regulated under this act. But remember, Inland Revenue Department is the controller, and they will have to take the primary responsibility to ensure the contract between that organization and the entity that is running, operating RAMIS will have to be looked at carefully to see whether the liabilities are properly managed so that the penalties under the Data Protection Act will not land only on the IRD, but ensuring compliance by the contracting party, which is the processor. So remember, when it comes to the Department of IT Management, you all run ITMIS and many other projects. In those instances, if personal data records are involved, and I know the Treasury also is involved in salary processing of large number of governmental organizations. So even protecting the staff, the entire public sector is going to be a responsibility in terms of governance under the Data Protection Act. Why? Because all of you in this room and all of your subordinates and the entire public service would be protected as data subjects, and they would have certain rights to know what records you have about them and how it is processed. So those are some aspects we will cover later down the line. Processing and some other technical definitions are there. I will skip all that in the interest of time. Moving on, here are examples of controller-processor relationships that can happen. So I have mentioned a few here: an insurance provider, a telecom SLT dialogue kind of entity that collects all our personal records to provide a service, a bank collecting records when we admit children to schools, Department of Registration of Persons, Immigration, Motor Traffic Department, IRD. All of these will be deemed controllers which are regulated under the Personal Data Protection Act. And then, of course, the outsourced contracted party providing them a service will be a processor under this act.